My name is Joshua Marks from JM Law Group, law firm here in Philadelphia, Pennsylvania, and I represent entrepreneurs, real estate investors, and small business owners. I want to talk to you today about something that is very important, and that is the representation of a buyer in a residential real estate transaction. I have a lot of buyers that call me all the time, especially now with the first-time home buyers tax credit having been extended by Congress. And a lot of buyers have never been through the process before. It's really important if you're going to buy a home, which for most people is the most significant investment they're ever going to make in their life. Very important to have legal representation in that transaction, even if you have a skilled realtor advising you. Remember, realtors cannot practice law, and there are many provisions in your agreement of sale which require legal advice and legal interpretation. So get yourself a skilled real estate lawyer. I want to give you 5 quick points today to be on the lookout for if you're a buyer in looking over your agreement of sale. The first is your mortgage contingency clause. The mortgage contingency clause is very simple. It says your transaction is contingent on you getting financing for your transaction from the bank. What I want you to make sure of are a couple of things in your mortgage contingency clause. Number 1, you specify the dollar amount that you're actually seeking from the bank. So you're making your deal contingent on you getting that dollar amount financed by the bank. Secondly, I want you to make sure that you specify a maximum interest rate. In other words, if you're not able to get a mortgage at or below that maximum interest rate, you have the right to void the transaction and get out of the deal. It's very important. So, for example, you might say the deal is contingent on financing not to exceed 7%. What happens if you can't get a loan below 7%? You don't know exactly what you're going to get when you're out there in the marketplace. This way you protect yourself and allow yourself to get out of the transaction should you not get the right interest rate that you can afford. Let's talk about another contingency clause. Point number 2, very important. You could put in there that the deal is contingent on the property appraising for the purchase price. So that way when the bank goes out, conducts its appraisal before it extends you the loan, that appraisal has to come back at least at the value that you're buying the property for. So the deal is contingent on the property appraising at the purchase price. You want to put that in your agreement of sale. Point number 3, let's talk about home inspections. This is the one part of a contract that I see homeowners get tripped up on all the time. If I'm representing a buyer, I want to make sure they are very well protected on the home inspection clause. And I want to give them the most advantage, the most power, put more of the decision making in their hands. So, what do you want to do? Very simple. You want the home inspection clause or the home inspection to be contingent on the buyer being able to provide the seller with a list of all the items that the buyer wants either fixed before settlement or credited toward the purchase price. Otherwise, this buyer has the ability to get out of the transaction if the seller doesn't agree to that list of demands. So let me restate that again. You want the contract to state under the home inspection provision that the buyer has the right, following inspection, to provide the seller with a list of any repairs that the buyer wants made prior to settlement, and if the seller refuses to make those repairs, buyer has the right to cancel the contract. The other kind of flip side to that is if you don't want to give them a list of repairs, you could also demand that the seller credits you the value or what it's going to cost to make those repairs, give you a credit against the purchase price. Either way, but make sure that the buyer has the ability to get out of the deal if the seller won't go through to it. Very important. Point number 4 is zoning. You want a statement in your agreement of sale that says where the seller represents what type of zoning class the property is zoned for, and that the property is currently being used in accordance with that zoning class. Very important. Imagine if you bought a property thinking it's a 1 to 4 family dwelling, in other words, a residential property. You paid the purchase price, you paid all this money, moved your family in, only to find out a month after you closed the transaction that the property is not zoned for residential use. You'd be on the hook for that. There's nothing you can do at that point. You've already closed. So make sure the seller puts a statement in that agreement of sale where they warrant or represent to you the proper zoning class for that property. And my final point of the day, very important. You want a clause in the contract, if you're the buyer, that says that the seller is limited to retaining your deposit monies as liquidated damages. Okay? Seller is limited to retaining deposit monies as liquidated damages. What does that essentially mean? It essentially means that if for some reason the buyer cannot go through with the transaction, or the buyer decides not to go through with the transaction, which in essence is a breach of contract, the buyer, or the most the buyer is going to lose, is his or her deposit monies. If you don't have that clause in there, the seller can bring a legal action and sue you in court and claim all types of damages above and beyond your deposit monies. Oftentimes I notice realtors, even experienced realtors, completely overlook putting a liquidated damages clause in the contract. Very important. So those are your 5 points today. Residential transactions, if you're a buyer, make sure you protect yourself. And I hope you'll join me again for my future videos on real estate and business issues. If you're on Twitter, come and follow me, twitter.com/lawmr. You can also check me out on Facebook. We have a Facebook fan page for our firm. Just look up JM Law Group. And if you have any questions that I can answer, please don't hesitate to call me. Our phone number is 215-832-3600, 215-832-3600, or email me, josh@lawmr.com. This is Josh Marks, thanking you for joining me today, and I'm the attorney that represents entrepreneurs, small business owners, and real estate investors. If there's anything I can do for you, please feel free to reach out to me. Have a fantastic day. Thank you.